Sure. For those of y'all that don't know me, or for those of you who I have not met, I'm Madeline Langer. I'm proud to serve as the dean here at Loyola. This lecture series was started in 1986. Brendan Brown was a very distinguished professor here. He joined this faculty in 1954, actually the year that my father was a graduating senior. My father had amazing stories about Professor Brown. He actually served as a dean for many years at Catholic University in D.C. before he came here and spent 2 decades. And the generosity of him and his family endowed this series because what he loved, what he engaged in, what he thought about was scholarly discourse. The importance of being able to sit in a room and listen as a community to someone who has views that may be like yours, may be different than yours, may cause you to think a little differently. And I can't help but reflect on what he would think about the current climate and where we're not free to do that as much as we ought to be, where we're not so free to talk about our views and our thoughts for feeling of being either canceled or disagreed with or disliked because of a view that you hold, and what a loss that is for our community. So I'm really just thrilled that Loyola continues this series and invites such distinguished speakers to share with us their thoughts and their views, and you as law students, for those of the law students in the room, to open your minds to a view that you might not have thought about before, and to think about how to challenge that view or agree with that view, or maybe even more importantly, to advance that view, to advance it to a place where it can go in better service to a better community and a better world. So without further ado, are you introducing our speaker? Professor Medina. I'm going to introduce Professor Isabel Medina, who will introduce our speaker. Sir, thank you for being with us. I'm really looking forward to having you. Professor Medina.
Well, I am delighted to be welcoming Ahilan Arulanantham, Professor of Practice and co-director of the Center for Immigration Law and Policy at the UCLA School of Law. Ahilan teaches in the law school and also maintains an active litigation practice. He has successfully litigated a number of cases involving immigrant rights, including Franco Gonzalez versus Holder, the first case to establish a federal right to appointed counsel for any group of immigrants, Jennings versus Rodriguez, which secured the due process rights of immigrants jailed for years while litigating their deportation cases, and most recently, Ramos versus Nielsen, a challenge to the Trump administration's plan to end the TPS program for immigrants who have lived here lawfully for decades. And those of you who have taken immigration and citizenship law will probably recognize some of those case names. Ahilan has argued 3 times before the United States Supreme Court, most recently in the fall of 2021, on behalf of Americans of the Muslim faith who were targeted by the federal government for surveillance because of their religion in FBI versus Fazaga. He's also testified before the United States Congress, served as a lecturer at the University of Chicago Law School and at the University of Irvine School of Law, where he taught on preventive detention. Ahilan's parents are Sri Lankan Tamil immigrants who left Sri Lanka to escape race discrimination and sporadic violence. Several years after they came to this country, the Sri Lankan Civil War began, causing much of his extended family to flee Sri Lanka. Ahilan has remained interested in promoting human rights in Sri Lanka and has also represented several Sri Lankan Tamil refugees during the course of his work with the ACLU. Because prior to joining UCLA, Ahilan was senior counsel at the ACLU in Los Angeles, where he worked for nearly 20 years. Ahilan also worked as an assistant federal public defender in El Paso, Texas, and as a law clerk on the United States Court of Appeals for the Ninth Circuit. In 2007 and 2013, he was named one of California Lawyer Magazine's Lawyers of the Year for Immigrant Rights, and has repeatedly been named to the Daily Journal's top 100 lawyers in California over the last decade. In 2010, he received the Arthur C. Helton Human Rights Award from the AILA, American Immigration Lawyers Association, and in 2014, he received the Jack Wasserman Memorial Award for litigation to protect the rights of vulnerable immigrants. He was named in 2016 a MacArthur Foundation Fellow, and he is a graduate of Yale Law School, Oxford University, and Georgetown University. And I know he's going to speak for longer than I just spoke. Please join me in welcoming Ahilan.
Well, thank you very much, Professor Medina, for the very kind introduction, and really for all of you for inviting me. It's an honor to give this lecture, especially knowing what we've been told about its intellectual origin. I come here from UCLA, a school which is currently actually under pretty significant threat from the federal government seeking to impose a hefty fine on UCLA, and I'm not afraid. I'm here to talk to you about some ideas that would probably be pretty controversial, but that hasn't stopped me and many, many other colleagues of mine, both at UCLA and in law schools and other universities around the country. So I really appreciate all of you coming here to hear me today. I want to describe the close connection between three important currents that we see in immigration law happening sort of right now. One of them is the idea of immigration law and deportation law in particular as a mechanism to engineer the racial composition of the United States. It's a difficult topic. It's not something that you definitely necessarily want to talk about, but I think it's really important and we have to talk about it. Another one is specifically how that is happening with respect to two immigrant communities in particular, Venezuelans and Haitians. And I want to focus on them mostly because I've been involved working on cases representing them for all of this year. Actually, I've been fortunate enough to be off teaching now for a whole year, and I've spent that year litigating federal immigrants' rights cases, and particularly cases involving people from those two communities and some others. And the third thing is I want to kind of bring to this my identity, which Professor Medina kind of touched on, somebody obviously born in this country, but from myself, a refugee community, insofar as my family is Sri Lankan Tamil, and that's sort of my kind of background. And so I hope you'll listen to this talk bearing those sets of things in mind. And now, all important, we will see if the clicker works. It does. That's brilliant. Okay. So this is me on the steps of the Supreme Court. It was taken right before the court heard the first case I argued there in 2016. And for me, it feels a little bit like a bookend. That was not even 10 years ago, and so much has changed in the intervening 10 years. And I think of it particularly because the last case I had in the Supreme Court actually was just decided, just came down this past Friday, actually just 4 days ago. So it's actually, the bio wasn't even updated to sort of capture all of that. And that is actually a TPS case, one involving temporary protected status, which I'll tell you all about. It's actually later than the one that Professor Medina was mentioning in the introduction. This one was not argued because they're not doing that for a whole bunch of really important cases right now, actually. In fact, it's the second one that they've issued in that case, which I'll talk about in this talk. And in neither of them, they hold an oral argument. And unlike the one in 2016, which I spent, months and months preparing for the briefing and the argument, this one, the whole thing went down in less than 2 weeks, actually. So a lot in that way has changed. And for me, it kind of mirrors changes in my understanding and thinking about what immigration law is and how it functions. For much of the early part of my career, I thought of immigration law fundamentally as a set of rules designed to figure out in an orderly, rational way who should be allowed to come into the country and who should be allowed to stay. And of course, the basic ideas, principles operating under it are things you would all kind of imagine: family unity, economic prosperity, and humanitarian protections. And this was kind of what immigration law was. Now, it didn't mean that it was all perfect, obviously. What I was litigating against often, me and many other people in the immigrants' rights movement, were places where there were irrationalities and gaps between those basic ideas and how the system was working in practice. A number of those were caused by the fact that the due process revolution that had changed so much of criminal law and other areas of law had not fully come into immigration law. And then other parts of it, I would say, were caused by sporadic bouts of violence, sporadic bouts of discrimination that were products of extreme events. And here, particularly, I'm thinking about the 9/11 attacks, because my career actually started in the year 2000 in New York, from 2000 to 2002. So, when you see, say, immigration detention, which is a system of imprisonment without trial for people, or the absence of counsel, the fact that people get deported in removal proceedings, in hearings against trained prosecutors without themselves having a lawyer, or the rampant discrimination that operated against Muslims for so long in various parts, Muslim immigrants in various parts of our immigration system, these were products, like I said, of these kinds of irrationalities, but they weren't like the norm of the system. And in fact, if you could bring these injustices in front of judges, federal judges, and show them these gaps between how the system was supposed to work and how it was actually functioning, that was the way that you could produce legal and social change. And I have to tell you now, especially thinking about the last 10 years, I think there are elements of that picture that are right, but in some ways I think it's actually fundamentally quite misguided. Because I actually don't know that that description takes account of how so much of immigration law has actually worked. Instead, I think it's about something else, which is, as I said, a way of engineering the racial composition of the country. And that this is actually how immigration law has functioned from the very beginning. Now, if you think about it that way, one thing that happens is it changes the way you think about immigration law. At least for me, it changes the way I would have been taught it, because it's not the way that I would have taught it. Immigration law can be understood as actually being older. People often think about it as starting, federal immigration law anyway, as starting in the Chinese exclusion area. How many people here know Chinese exclusion? Does that ring a bell for some people? Yeah, so that started in like the 1870s, 1880s. But on this account, if immigration law is actually part of a process of racially engineering the composition of the country, then really you got to think about it from the start of the country itself and Native American exclusion. And then you have a whole set of laws in the late 1700s and early 1800s that function to control the movement of black people, both free black people, whose movement is heavily restricted during this period by state laws as well as federal laws, and then also, obviously, enslaved people who are regulated through the laws governing the importation, I put importation in quotes, obviously, of enslaved people. And then Chinese exclusion actually kind of makes sense as part of that project. It's like a continuation of that same project. So these are very uncomfortable things and difficult to talk about, but I think that if you think about them that way, then we look at what's happening now also in a different light. Maybe the spots where the system actually functions consistent with our values could be understood more as exceptions. And the way that the system often operates today is actually consistent with how it has operated for a really, really long period of time. And at least for me, personally, it's helped to make sense of a lot of what we've seen, both over the last 10 years and particularly in the very recent past. So I want to talk about those things today. Let me see if I can get this thing to move. I can. Good. So I want to talk about those things today and do that by taking a deeper dive into one example of this kind of racial engineering that's happening right now. And that concerns the treatment of over 1 million people who are refugees to this country from, as I said, 2 places, Venezuela and Haiti, because I've been in the process of trying to protect them in court. But just as a way of setting the ground, sort of, for that part of the conversation, I want to start, if you'll indulge me, with a bit of biography, because as I was mentioning, or autobiography, I should say, because as I was mentioning, I come to these refugee issues, I won't, sort of hide it. I come from a particular perspective, which is the perspective of somebody who is part of a refugee community. So if you'll indulge, just for a little moment here, this is a picture of a person I know well, because it's me. I am the younger of 2 brothers. And I want to know who here is a younger sibling in a family? Oh, so many of you. I want you to know that I see you and I feel your pain. And I feel the suffering that I know you have endured by being a younger sibling. How many of you shared a room with your older sibling? Okay, so then all of you know that if you share a room with your older sibling, what that really means is that you're living in your older sibling's room, right? And that's definitely how it was for me. I lived in my brother's room, and I didn't like it. I thought it was wrong. And so I advocated very strongly for winning the right to my own room. And actually, this captures a really important moment, because one way I did that was try to get his buy-in by jumping on him. And that's what's happening in this shot. And it worked. And at the age of 10, actually, what had been my father's study was converted into my own room. And on my 10th birthday, I got to move into it in a little house in Lancaster, California, which is where I was growing up. But it was a very, very short-lived victory. And the reason for that, as Professor Medina had suggested, is because I was born here, but my family is from Sri Lanka. And I'm part of a community that's called the Sri Lankan Tamils, where a majority in the northern and eastern parts of the country, the green and blue, but a minority, a racial minority, elsewhere in the country. And my parents, as she had mentioned, left Sri Lanka in the 1970s. They weren't fleeing at the point of a gun. To be super clear about that. That is not what was happening. They faced race discrimination in employment and in language, and also sporadic violence, which had happened in like pogroms around the country that had happened when they were growing up. Now, they didn't know it at the time, but they actually owed their presence in this country to the civil rights movement, and particularly, of course, to this man, Dr. Martin Luther King. And this is a weird thing. Even I did not understand this for many, many years, even after I was doing immigration work. See, from 1924 to 1965, virtually all immigration from Asia and Africa had been banned to the United States. And even before then, there were various limits that had operated on immigration from Asia. And the civil rights movement and leaders in the civil rights movement understood that that was highly problematic, and that it was very difficult to build a multiracial democracy in this country if simultaneously immigration from all around the world was regulated based on race. And so, just along with a lot of other laws that people can think about, the Voting Rights Act and the Fair Housing Act and Title VII and all this, the civil rights movement viewed changes to the immigration code as fundamental to their project and achieved a substantial victory in 1965. The 1965 Immigration Nationality Act did not ban all discrimination in all aspects of the immigration law, but it did significantly change the limitations on immigration from Asia and Africa and had the effect of opening those. And so when my parents came just a few years later, in the early 1970s, what made it possible for them to come was the fact that these changes had been made. And in their case, that turned out to be a really good thing. Because in July of 1983, when just a few months after I had gotten my room, the civil war in Sri Lanka started. And there were widespread anti-Tamil pogroms throughout the country. 3,000 people were killed. 150,000 people were displaced into internal refugee camps all around the country. And included in that number were my close relatives, my parents' siblings, my cousins, were all displaced. Some had their houses burned. It was awful. And I still remember this. I remember actually my parents gathering me and my brother on the stairs of our house in Lancaster to tell us that there had been some troubles in Sri Lanka. And the people we knew because we had gone and visited, that they had been displaced and that they were going to be coming to stay with us. And we were little kids and we're like, well, how long are they going to be coming to stay? And they said, well, we don't know. It might be a few weeks. It might even be a few months. And as it turned out, actually, it was more like a few years. First, 15 people, my parents' immediate siblings and their families, came to stay with us in a house built for 5 in Lancaster, California. They eventually settled, some in California, elsewhere in the United States, but also in other places all around the world. But then my parents took in others, more distant relatives, friends, the relatives of friends. For about a decade, we had people living in our house in in Lancaster, California. And this was, by the way, very common. It was common in our community, and it was very common in refugee communities among Sri Lankan Tamils all around the world. And I think it's a common experience for refugee communities for lots of people, right? So what did it mean? I mean, one thing it meant was that I lost my room. I spent 2 years sleeping on the floor next to my brother, mostly my parents' bedroom. I look back now and it's like, wow, it was rougher on them than it was on us, but it was like rough on us. It was rougher more, of course, on my extended family, right? People who had to come here from Sri Lanka. And it gave me a window into that experience, from my cousins who were like my own age going to public school in Lancaster, California for the first time after having left northern Sri Lanka, to the older ones who were like just starting their careers, and then it all got upended, and their university degrees are no longer good, and they have to redo this and retake that just to try and establish themselves, and they don't even know where they're going, to my grandmother. My grandmother was born in Jaffna, Sri Lanka, at a time before there were even any cars in that place, who left Sri Lanka for the first time on a plane to come first to the US and then eventually to the UK, where she lived out the last years of her life. So 25 years later, we did a reunion, and this is like an Arulanantham family reunion picture. And as a picture, it's not the greatest. It's like shows you the chaos that happens when you try to do an Arulanantham family reunion picture, which is not an easy task for anyone. That's actually my niece, and you can see she's caught red-handed trying to annoy her cousin, like right there. She's like right there as the camera shot gets taken, totally caught. But it's actually a really interesting picture, even if it's not a sort of perfect portrait. So there are more than half the people in this picture who are born in Sri Lanka. But then there are also Americans, Brits, Canadians, Zimbabweans, and Australians in this picture as well. Okay, people born in those places. And to me, I always think it's interesting to ask, like, okay, can you tell which are which? And no, of course, there's no way to do that, right? They're all just part of one family, and I like to say I love them all the same. That may not be entirely true, but of course you get what I mean, right? It's just all a bunch of people who just want the same things. They want a stable life for themselves and for their family. And that kind of basic idea has always undergirded my work. It's not to say that it means that everybody in this picture should have the right to go to stay in whatever country they want. That's a much more complicated question. It's not even to say necessarily that we should have humanitarian protection laws, although I believe we should. I absolutely believe we should. But what it does mean is that we always have to remember that the immigration laws, like all laws, but the immigration laws are about people, and the people have stories and connections and families and loved ones. And that is sort of undergirded everything that I've done in this field. So that's the sort of background setting that I wanted to put into this talk. And let's turn now to some things more of the present day, right? So Sri Lanka is not the only country that has gone through massive violent upheaval and that has caused lots of people to flee, many others, of course. And one of them, really important, is Haiti. And I should say, there have been refugees coming to the United States from Haiti since both countries first came into existence, going right back. And one of the very first humanitarian protection laws, ironically, in the United States' history is from 1791, a law that granted Haitians, white Haitian slavers, financial compensation if they could come to the United States immediately after the Haitian Revolution. And arguably the first deportation law that actually caused deportations in the history of the United States is a law in 1803 that was a federal law that backed state laws prohibiting the entry of free black persons that was targeted in practice in large part against Haitians, who people here were scared were going to come here and foment revolution, that is the end of slavery in the United States, after having successfully done the same thing in Haiti. So there's a long history of immigration laws connected the United States and Haiti. Well, fast forward a whole bunch. During the Biden administration, there was a huge amount of violence and political upheaval and instability in Haiti, which of course is still continuing to this day. And there were many, many thousands of Haitians that tried to come into the United States. And the Biden administration had two really different policies. On the one hand, they were often quite brutal. They deported many, many Haitians, stopped many of them at the border without even giving them the opportunity to apply for asylum, which is what produced this, unfortunately, rather famous set of pictures of border patrolmen on horseback with whips, catching Haitians who were trying to get into the United States in order to be able to apply for asylum, and then summarily expelling them without giving them that opportunity. But also at the same time, the Biden administration ran programs to allow thousands of Haitians to come to the United States through parole. It's like a different process that allowed them to come, particularly if they didn't come to the border and just applied from abroad somewhere. And for those who were here, they provided them something called temporary protected status. And ultimately, by the end of the Biden administration, there are about 500,000, about 500,000 Haitians who were protected, given the right to live and work in this country under the TPS statute. In addition, another country that has gone through massive, violent upheaval from which many, many thousands of people have fled is Venezuela. In fact, the issues surrounding that are much bigger than those involving even refugees coming to the United States. About 8 million people have fled Venezuela as a whole over the course of something like the last 10 years because of a variety of political and economic problems produced largely, I think, in significant part anyway, by the Maduro government in Venezuela. About 1 million of those, 8 million, have come to the United States. Our government formally recognized the refugee crisis happening in Venezuela on January 19th, 2021. Did you get that date? January 19th, 2021, that is the last day of the first Trump administration. President Trump issued an executive action called Deferred Enforcement Departure that protected nearly 300,000 Venezuelans who had come to the United States in the preceding years. And his move granted them the right to live and work in this country. Yes, that's right, President Trump granted them the right to live and work in this country. People are like, that can't be right, for 18 months. And then 3 months later, the Biden administration took that same population, more or less, and protected them under something called temporary protected status, the statute, the same one that they used also to protect people from Haiti. Venezuelans continued to come to the United States during the Biden administration in very, very large numbers. More than 300,000 came between 2021 and 2023. And ultimately, by the end of the Biden administration, there were more than 600,000 Venezuelans. A lot of people, more than 600,000 Venezuelans who were protected under temporary protected status. And very late in the Biden administration, January 17th of the last day, effectively, of the Biden administration, the protections, temporary protected status protections for this group of 600,000 Venezuelans were extended by DHS Secretary Mayorkas to last through October 2026. Okay, so we got 500,000 Haitians, 600,000 Venezuelans, who are all protected for TPS into 2026, the Haitians a couple months shorter, by the end of the Biden administration. Now, let me take a brief detour here to tell you a little bit about this law. Who here is in immigration law or has taken an immigration law or immigration law course of some kind? Some, not a lot. Okay, so TPS, temporary protected status, is a status that was created by a law that Congress passed in 1990. And this presents one of those moments when immigration law was not working, I would argue, to advance kind of a white supremacist notion of the racial composition of the United States. And I think it's really important to understand that. It's when you say the immigration laws work to engineer racial composition, that doesn't mean that that's the only thing that they do. It's much more complicated than that, right? But people, sometimes the immigration law works one way, sometimes it works a different way. Even the racial line moves, right? There's sometimes when people are seen as white, other times when they're seen as not white, and all kinds of things like that. So I want to make sure that I acknowledge that complexity. So here's one of those moments when the law was doing the opposite. TPS was actually written in large part in response to grossly discriminatory treatment that the government had sort of enacted in humanitarian admissions programs, coming out of a time in the 1980s when, for example, Cubans, who were sort of seen as mostly white, were allowed to come into the country, while Haitians, seen as black, were not. And when Nicaraguans, actually, fleeing a communist country, were allowed to come into the United States, while people from El Salvador and Guatemala were repeatedly denied that opportunity because they were fleeing countries that were aligned with the United States. There was a huge movement, a lot of it actually by Salvadoran immigrants in the United States, to end this program, to end that kind of discrimination and create a program that would be more neutral in how it was approaching humanitarian protection. And so that's actually a big part of how the TPS statute came into existence. And this set of people, a bipartisan group, including George H.W. Bush, the senior, and Ted Kennedy in this picture, Bob Dole in this picture, Paul Simon, a Democratic senator, a bipartisan group came together and created this law, which created objective conditions under which people from fleeing other countries would be protected. And the law was incredibly successful. It was actually used by people from both Republican and Democratic administrations to protect people who were coming here fleeing famine, natural disasters, civil conflict, and a whole variety of other similar kinds of problems. I just want to get into the mechanics of it a little bit. I won't belabor it. But the statute gives the DHS secretary authority to designate a country for protection if it is not safe to accept back the return of its nationals. And the way the law works, the secretary may designate a country if it meets these unsafe conditions, but doesn't have to. So when it comes to that first step of designating a country, even if things are really terrible, it doesn't have to be designated. That's a choice that gets to be made. The law does not require it. Okay? But once the designation has been made, then TPS status is extended unless the secretary decides it no longer meets the conditions. In other words, unless the secretary decides it is now safe. So what this means is if you have a war in a country and the war is going to go on for a long time, well, then you're saying these people are going to remain protected in this country until the secretary decides that now the country is safe. Right? And this is, I think, a complicated thing because it's temporary protected status. Some people are like, well, what does that mean if it goes on for 15 years? But Congress knew actually when they passed this law that sometimes the wars, like the civil war in Lebanon, for example, had gone on for 15 years. And the way the law was actually enacted was like, look, once we've protected people, we're going to say that you have the right to live and to work in this country. You shall not be detained under the immigration law, and you shall not be deported so long as the conditions in your country remain unsafe, and I should add, so long as you have virtually no criminal history. Even 2 misdemeanors or a single felony render somebody ineligible for TPS, but as long as that does not exist, then the protection continues to function. Now, one thing the TPS statute does not do is change anything about the Constitution. Right? All it does is a law enacted by Congress that's supposed to create objective conditions and end discrimination in the humanitarian protections. But you might wonder, like, who cares? Why does that matter? Why would we need a law which stops race discrimination, for example, in humanitarian protection, when you've got this thing? This is the 14th Amendment. It says, no state shall deny to any person the equal protection of the laws, right? And we know that the baseline protection there, that state officials cannot enact government policy that is motivated by racial animus, where the goal of the policy is to harm people because of their race. Right? That protection is surely, it's robust, right? It's one of the most robust protections in our constitutional system. Right? Courts have long applied it even to facially neutral systems. Like you have a neutral jury selection system, but if you use it in a discriminatory way to target people from one race, that's unconstitutional. The Supreme Court said in 1879. It applies not just to states, even though it says no state. It applies to the federal government. The Supreme Court said that. Actually, during World War II, ironically, in the Japanese mass incarceration cases, in Korematsu and then in Hirabayashi. And they continue to apply it in a very robust way today. You could argue about whether it's actually appropriate to use it to end affirmative action, or not, but that is what the Supreme Court did. And if you read what they said, the guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal. And what are we talking about here? We're talking about laws providing humanitarian protection to people who are fleeing persecution, right? Wrong. Or at least really unclear. Really unclear. Because there's one realm of law, at least, and maybe there be others, but certainly one, where it is not at all clear how these rules apply, and that is immigration law. The Supreme Court held in 1889, in the course of a case that upheld one of the early Chinese exclusion laws, the case is Chai Chan-ping, that the government has very broad power to regulate admission of people coming into the country. They said the power belongs to the federal government as an incident of sovereignty. That's the reason why the federal government has it and not the states. That's what they explained. And went on to state that it could not be restrained on behalf of anyone. Now, this case okay, is decided in 1889, and it's dripping with racism if you read it. Which is not to condemn the people who wrote it. I mean, it's written in 1889 at a time of virulent anti-Chinese sentiment, at least among some sectors of the country. It says things like it characterizes the Chinese people as vast hordes who are crowding in upon us. It says if the government considers the presence of foreigners of a different race who will not assimilate with us to be dangerous, then that can justify their exclusion, even though there are no actual hostilities taking place, which sort of suggests that Chinese people are kind of inherently somehow like hostile or dangerous. If you read the case, I mean, there's worse lines in it that I have not put up here. But at some level, this is not a shock. It's written in 1889, 7 years before Plessy v. Ferguson upholds separate but equal. And by the same, the Fuller Court, Supreme Court Justice, that ruled that states can ban women from practicing in law. I mean, that obviously, these are opinions that are consigned to the dustbin of history, right? Like, so what? Except not. Chai Chien-ping has actually never been overruled. And this basic idea, plenary power, and the notion that the federal government has extraordinary power, perhaps even power that is, if not entirely immune, then largely immune from other constitutional protections, is an idea that still pervades the constitutional law in immigration throughout, actually, our doctrinal schemes. And so just to give you one example, a pertinent one, which you'll hear come back later, when the Supreme Court upheld the Muslim ban during the first Trump administration, one of the reasons they did it, central to their reasoning, was that the review is limited to whether the executive can give a facially legitimate and bona fide reason, meaning basically that we don't get to look at all of the other things that might have been said to justify this, like the numerous statements that seem to reflect animus against Muslims. Because if you have to just look at the four corners of the opinion, of the reasoning given in the ban itself and the justifications immediately given kind of for it, if those don't speak to racial animus or religious animus, then it's not present. And what did they cite? They cited a case called Kleinies v. Mandel. I won't get into the details of it. But what did that case cite? Chai Chien-ping. It's just 2 hops away. Right? So these ideas, they're still operating in our law. They've never been eradicated, and they play a huge part in how litigation happens today when it comes to challenging various aspects of federal immigration law. Now, fast forward to a year ago, during the presidential campaign, a year ago, right? So it's before the inauguration, okay. The Biden administration, as I said, had used TPS extensively to protect people from many, many countries, including from Venezuela and from Haiti. Of course, as I mentioned, the Venezuelans, at least, the first formal recognition of them happened during the Trump administration. That was something that Trump had done in his first term, but that didn't stop, Donald Trump from beginning to attack these refugee communities. And he launched a campaign, of course, calling for the largest mass deportation in US history. We're living in the middle of that right now. And when he announced it as a candidate, he specifically focused on 2 places, Springfield, Ohio, and Aurora, Colorado. And the reason he focused on those was because that's where there were 2 among many places where there were significant refugee populations of people from Haiti and people from Venezuela. And weirdly, or maybe not that weirdly, candidate Donald Trump then started making up just crazy, weird things about people from these 2 communities. And one of the first lies he told about them was this lie that in Springfield, Ohio, where there had been a substantial number of Haitian immigrants who had come into this community who had TPS, he said, they're eating the dogs, and they're eating the cats, they're eating the pets of the people who live there. I'm like, that's really weird. Why did he say that? Why did he say that they're eating the dogs and the cats? Well, one reason, super important to understand, is Miss Sassy. This is Miss Sassy, the cat, at the center of the Ohio pet eating controversy. Okay? Now listen, oh, hold up there. Now, her owner, who's an elderly white woman, had reported her missing while wearing, by the way, and at least gave the report to the Wall Street Journal, a Trump 2024 shirt, and another interview also a cap, a MAGA cat. But she said that she suspected that Miss Sassy had been caught by her neighbors and had gone missing. And the neighbors were Haitian refugees. Okay? And for 48 hours, that's what the world thought. Everybody thought Miss Sassy was gone. Okay? But then I feel like I'm not sensing the concern for this cat from this audience that is warranted. It just seems odd to me. I'm not kind of getting that from everyone, but I would be very worried. But then it turned out 2 days later that she was discovered. And to her credit, the owner actually reported it to the police, and then took interviews about it actually and said, yeah, it turns out she's actually here. She was found in my basement 2 days later. So one really important question, which for me I've wondered about, her picture is in the paper, okay? And look, this is like one of those big lawn chairs, like that you sit outside in. She takes up like 2/3 of that chair, right? And something that the owner said, which is also fascinating, Miss Sassy is a Maine Coon cat. Do people know what a Maine Coon cat is? Some people do. It is the largest domestic house cat breed like in the United States. So like how did this like mountain lion go missing? She went missing for 2 days and then was found. It's amazing, right? How did this happen? It's like so incredible. So this is like one conceivable reason for why Trump and J.D. Vance also actually were saying that they're eating the pets. Right? But there's another reason, and maybe a more insightful answer, although I remain obsessed with Miss Cassie, and I feel like one of the things I really would love to do is go meet her. But this story that they started repeating, it is an old, racist, anti-immigrant urban legend. Stories of immigrants eating pets were repeated in the 70s and the 80s as to people from Southeast Asia, actually, Vietnamese immigrants. They were repeated in the 30s and 40s as to both Mexicans and Italians and Jewish people from South and East Europe. And even before that, Chinese immigrants. During 1888, the presidential campaign, Grover Cleveland actually distributed trading cards of Chinese people eating rats. And if you think, it's like another thing I learned, if you think like that's not the same thing because they're talking about rats, during that time period, tons of Americans kept rats as pets, actually, something that I totally did not know. And in fact, some apparently still do. And so like here we see this arc of history, right? Like it's not just the law that has not been eradicated, but even the same racist tropes are being recycled. Now, I mentioned the other group targeted was Venezuelans, right? And I told you that protection for them started during the Trump administration, first Trump administration. It didn't stop Trump from vilifying them when he was on the campaign trail, right? And so the lie that Trump started to repeat on the campaign trail about Venezuelans was that they were all coming because Venezuela had started to empty out the prisons and jails and mental institutions and send these people to the United States from those. And look at these statements. Kamala Harris decided to empty the slums and prison cells of Caracas, Venezuela, and many other places, and now we have to live with them. Kristi Noem, who's now the DHS secretary, but was then on the campaign trail stumping for Trump as the governor of North Dakota. Every illegal immigrant broke the law, and nations like Venezuela are using our open borders to solve their own crime and mental health crises. Donald Trump will take care of this. And then December 16, after he'd won the election in Durham, North Carolina, he talked about the same thing and then connected it. If you weren't sure, connected it for you. They're poisoning the blood of our country. Because this idea that like defective people with histories of prison and mental health problems are coming here to poison the blood, this is an idea which is old. It comes back from the 1920s, when eugenics actually had a huge amount to do with what produced a lot of our immigration policy, including that ban I told you from 1924 to 1965, virtually all immigration from Asia and Africa were banned. It was because eugenicists said that people from those parts of the world, like me, or at least my parents, were defective, and that they would poison the blood of the country. So as we all know, Trump won, and once in power, his administration moved very quickly to terminate the protections of TPS for people from these two different countries. And this was clearly illegal. as I mentioned earlier, because the law requires that once the protection has been granted, it must continue extended for the time period that's specified, 6, 12, or 18 months, and in this case it was 18 months, and cannot be taken away unless there's a determination made that the country is safe, and that the determination has to be made. I didn't even show you all these before, but the determination to be made, it has to involve a country conditions analysis, which requires consultation with people from the State Department. And there's other kinds of process constraints, in addition to the timing constraints, that are on this kind of decision. But here, the administration asserted, the Trump administration now I'm talking about, that they had implicit authority, not written anywhere in the law, to take away TPS status early. This is what they said that they could do, and then they did it. They first did it for people from Venezuela, and then later did it for people from Haiti as well. And for me, I think it's really important to say, I think they did this because it was really important to take a large population of people, take away their immigration status, people who have lived here recently, and where the government has good address information on them, and make them vulnerable to deportation. Because the effect of what they were doing was stripping the immigration status of people who had it. And in this case, we're talking about combined more than 1 million people, who would lose immigration status and become vulnerable to deportation. And so we took the Trump administration to court. It was very good timing in a sense. I was not teaching. I had a full year off to do this kind of litigation, which I thought was going to be mostly in the district court. And when I say we here, I'm referring to an organization called the National TPS Alliance, which is a remarkable group formed actually during the first Trump administration, mostly composed of people who are refugees from other countries that have had TPS protection, former and current. And they believe that no matter where you have come from, no matter what reasons you fled a communist country, fled a right-wing country, fled because of an earthquake, doesn't matter. If you've come here seeking protection, you should be allowed to stay if your country is not safe. Okay? And then they also believe, for people who have lived here for a long time, that they should be given the chance to stay here permanently. That is their view. And so you see in this picture a leader actually from the Haitian community in Boston, Venezuelans holding the Venezuelan flag behind them, these TPS holders. And then actually that's Doris Landaverde, the woman who's holding the green flag from the National TPS Alliance, herself a TPS holder, Salvadoran refugee, and one of the leaders of the alliance. And it's an amazing thing. They bring together communities seemingly quite disparate to advocate together for the concept of refugee protection. And I actually had started working with them during the first Trump administration when we worked on a case that succeeded in protecting about 400,000 people from 6 different countries that the Trump administration had also tried to illegally take away their TPS status. That's the case Ramos v. Nielsen, which Professor Medina mentioned. So we filed suit in March, and the first thing we argued was that as a preliminary matter, these set of people should be protected while the case remains ongoing. Okay, we sought preliminary relief for this group of people. And it was really urgent because there were about 350,000 Venezuelans who were set to lose their status in April. So we had just a matter of a few weeks to try to protect this population. And we made 2 sets of arguments. One argument was that you can't take it back. There is no not written in the statute power to take away a TPS extension. Once it is granted, it has to be, like the law says, it is extended. It must maintain for the time that's specified. It can only be taken away if the country is found to be unsafe. And the other argument we made was that these decisions, like it or not, they're motivated by racism. And we cited all these statements that I was mentioning. So, several truly intense weeks. You prep and prep, you write and write, you research, try and get all the details, take declarations from all these people, you organize them, people who have the courage to come out and sue the Trump administration in an era like this, and they are. There's amazing immigrant leaders who are willing to do this stuff. And then after all those late nights, the court sets you for argument. And so we got set for an argument in March, just days before the protections were going to expire for these 350,000 people. And we had a court hearing in San Francisco. And this actually, the person here, this is Pablo Alvarado. He's the head of an organization called National Day Labor Organizing Network, one of the founders of the TPS Alliance, an amazing immigrant rights leader and advocate, and himself, former Salvadoran TPS holder, former Salvadoran refugee. And when they come, they bring lots and lots of people. Like every court hearing I've had with them, the courtroom is full. Usually there's an overflow room. That is also often full. Next to him is Marta Arevalo, who's the executive director of an organization called the Central American Resource Center, another amazing refugee protection organization, very strong in California, particularly in LA and in San Francisco. They have offices in other parts of the country. And they also bring musicians. And they do like a rock concert, like on the steps of the courthouse. And sometimes you're arguing and the music is out there and it's like loud and you can actually hear the drums like going during your argument and you have to kind of ask to see if they'll like tone it down a little bit, which sometimes they do. They also, some people just stay out there and listen to the concert. And they said it's like, because we have to give it life, but I kind of think it might also be because they think court hearings are sort of boring, which, like there's something to be said for, something to be said for that view. So it was a huge rally, and we had this courtroom argument. And we focused a lot of our energy on debunking the false claims that were being made about refugees by Trump and Noam. And we had evidence. Economist experts, one who had won a Nobel Prize, and other people doing careful analysis of all the data out there to show that, among other things, the labor participation rate of these communities is higher than the national average, is 80 to 96%. A number of them have higher education, substantial economic contributions. And then also, we actually had people do this. It seems unnecessary, but this is what you have to do. You have to present facts in court. We did studies that showed that actually, and there's people that have done this, it's wild, there has been no decrease in the prison populations in Venezuela, or in the mental health population institutions. There's no like mass exodus of people from those places. They're the same as what you would expect as they've always been, right? And interestingly, the government did nothing to try to counter any of this evidence in the court proceeding. And of course, we talked about the racist statements, because we're not going to not talk about them. And the latter, I thought we had a really strong case for a bunch of statements, but especially for this one. Kristi Noem, who is the person who made the decision to terminate TPS for these countries, she is the DHS secretary, she signed the form. She went on national TV on Meet the Press the day after the TPS termination happened and was giving an interview explaining the decision. And she says, the TPP program has been abused. So we have to get the acronyms right. They don't always have to get them right. It's TPS, not TPP. But anyway, that's what she said. And she said, and remember, Venezuela purposely emptied out their prisons and mental health facilities and sent them to the United States. So we are ending the extension of that program. I was like, wow, I've litigated a lot of discrimination cases. You rarely get a causal statement. This is the reason we're doing it. And the reason is because of this reference to this age-old racist trope. And of course, we have historical experts in the record saying, yeah, this is a statement that goes back to poisoning the blood from 100 years ago during some of the worst kind of eras of racist policymaking in our time. Now, you might wonder, how do you defend a statement like this? And so I thought I'd show you the district court argument, actually. So I'm kind of cheating a little bit here. The district court argument, the lawyer really didn't have his heart in it. And so I decided not to show you that. But this is the Ninth Circuit argument, which comes later. So I'm going to go out of order for a second. And this is Drew Ensign. Do people know that name? Anyone? Drew Ensign? He is actually the lawyer, yeah. Good to see you, by the way. He is the lawyer who defended the government's decision to send Venezuelan planes to the prison in El Salvador. For any of you who follow the Alien Enemies Act thing that happened in the spring, that's him. And he came to argue on the government's case against us in the Ninth Circuit. And I think this is going to play. Let's see.
The statements by the Secretary and frankly by the President.
This is the judge asking him
by
first.
The Secretary saying specifically the Venezuelans purposely emptied out their prisons, emptied out their mental health facilities, and sent them here. Don't these seem to be, and I'm not going to get into all the different other statements that were made that arguably are racist, not only by her, but by the administration. What do we do with those statements? What do we do with, in terms of this decision to have been done about 2 weeks after they came in?
Your Honor, I think what you should do with them is approach them as the Supreme Court did in the Trump versus Hawaii case, where they are, made prior to when people are in office or remote in context from the decision at issue. They are not, they do not control the equal protection analysis. That's precisely how the Supreme Court addressed that in Trump versus Hawaii. You know, the vast majority of Secretary Noem's statements refer to before she was in office. I believe all of the statements of President Trump refer to when he was either campaigning or when he was in office the first time, which is, you know, very remote in time. And so I think you should approach them as the Supreme Court has directed lower courts to approach them, that those sorts of statements do not make out a equal protection claim.
You know, two things interesting about this. Notice how he's relying on Trump v. Hawaii. Remember I mentioned these ideas have not been eradicated from our law. Right? It's from Chinese exclusion is like a direct line, and here it is, being deployed to argue against the race claim that we're making in this case. Right? Second thing interesting, you know, he's just not being honest about the context of these statements, you know, to say, oh, these are remote in time before they come into office. And so I had a chance to try and answer that. But I feel obligated to begin by correcting the statements that were just made about the context of the Secretary's statements of animus, because as Mendoza was talking about, the vacatur happens 3 days after she comes into office, and the next day she goes on Fox News to give
By the Secretary saying specifically that
That's a different statement.
Purposely emptied out their prisons, emptied out their mental health facilities, and sent them here. Don't these seem to be, and I'm not going to get into all the different other statements that were made that arguably are racist, not only by
3 days later, the termination happens, not a very long time, Your Honor, and she goes again on Meet the Press to talk about this. And she says, I'm quoting now, the TPP program has been abused, and then she talks about the connections to gang activity, and then she says, remember, Venezuela purposely emptied prisons and mental health facilities and sent them to the US. So we are ending that extension of that program. So it's the justification given to the public for this decision the day after the decision was made. Seems pretty clear, right? Well, it sure was for our district court. So our district court issued an extraordinary decision ruling for us on the statutory claims as well as the constitutional claims. It's 78 pages, I think, I want to say. And it explained, this is my favorite passage, it's evident that the Secretary made sweeping negative generalizations about Venezuelan beneficiaries in toto. He said, acting on the basis of a negative group stereotype, generalizing it to the entire group is the classic example of racism. And this judge, this Asian American judge, then cited the cases from the Japanese American mass incarceration. Hirabayashi, Korematsu, the dissent, saying that the country's descending into the ugly abyss of racism based on an erroneous assumption of racial guilt. These are cited in the opinion. Okay. But then a strange thing happened. A strange thing happened. And this is the last part of the sort of sets of things I wanted to talk about today. The government sought what it calls a stay of the decision. Okay. And I don't have time to get into all the details here, but it's a procedural maneuver that the Supreme Court has always used a little bit for small things, but it started to use a lot and for really big things lately. What they did was they said, we want you to put this 78-page decision on pause, freeze it, make like it didn't happen while this appeal of this is going on. So we're going to appeal to the Ninth Circuit, but while we appeal, stop this thing. Okay. And back then, I mean, for those of you following the Supreme Court, now you're like, yeah, but back then, this was actually the first immigration case, other than the Alien Enemy Act cases, which actually they did not stay. It was the first case that went up there where the government was saying, stop, just stop all this, tell the court not to do it, or not even not tell just pause their decision. Okay, it's very difficult if you study civil procedure to even explain what this is. That's the entire thing. You've just read it. Okay. And although Haitians were still protected because they were not the subject of this preliminary relief order, again, for reasons I won't get into, a bunch of people in the Haitian community were wondering, like, this is what they just did. Are we next? Okay. Now, we didn't give up. Okay. The order said it applied only to the preliminary relief stage, and it didn't give any reasons. If it doesn't have any reasons, it doesn't create precedent, right? It has no reasons in it. And so we narrowed our case, we obtained additional evidence, and we went back to our district court. And we said, look, we want you to now issue a final ruling on at least a narrow portion of the case, on the Administrative Procedure Act portions, the part about taking stuff back, and some related issues about not assessing country conditions, issues related to that, not consulting with country conditions experts, which the law also requires. And these are just claims under the Administrative Procedure Act. Okay? And to his credit, because judges are humans, okay, and he saw all the attacks that came against him that has become a commonplace feature of legal system now. And I'm sure he knew that the Supreme Court would rather just the whole thing go away. But we were entitled to file for summary judgment, entitled to make our claims, and he heard them. And he ruled for us again. We won another exhaustive order. This one's 69 pages long, detailing the evidence we had marshaled under the APA, addressing both the narrow claims that we had prevailed on before and these new ones that involved some additional evidence. And as he explained, for 35 years, administrations from both parties had implemented this law, affording relief based on the best available information obtained by the DHS until now. And he found the Secretary's action is unprecedented in both the manner and the speed in which it was taken, and it violates the law. And he issued a final summary judgment in our favor. And the effect of that was to restore the TPS protections for the people who had lost it. Okay? And as soon as that happened, we went to the government. We're like, oh, what are you going to do about it? And they said, nothing. Nothing. They did not even actually update their website to reflect the court's ruling. We then went to the court and said, that's illegal. They have to update their website. They litigated that, and they lost it. And after they lost it, they did update their website, but immediately also, they filed for a stay to go back to the Supreme Court. This time there was a month gap. And I have to say, during that month, we worked feverishly. All the people from the NTPSA team, which is not only just me from UCLA Center for Immigration Law and Policy, but also the National Day Labor Organizing Network, the ACLU, and others as well. Big team of people working involved in this case. We worked feverishly to try and get people out of detention because there were all these TPS holders who were detained, and their detention is illegal if they're entitled to TPS protection. The government did not send a notice to all the ICE offices to say, let these people out. So we had to actually threaten to file habeas petitions, and we actually did file some of them, lawsuits, to get people out from illegal detention. And we succeeded. We actually got about 60 people out from detention, which is good. But there's 350,000 people who are entitled to status. Of course, not all of them detained. But that's what we did. And meanwhile, the government sought the stay. They filed for the stay in the Supreme Court. And on that same day, September 20th, Donald Trump tweeted this. And it's not tweeted, sorry, Truth Social. I don't know what you call those. He did this. So we want Venezuela to immediately accept all the prisoners and people from mental institutions. Do you remember the statement from the government attorney, how all the Trump statements are before he was in office, right? This is what he tweeted the day, sorry, I keep saying that, posted the day that they filed for relief in the Supreme Court. Okay? Lying about their criminal history. If you have even a single felony conviction, you're not eligible for TPS. Called them monsters, get the hell out of our country. And the Supreme Court granted it. They granted it this past Friday. Yeah, this past Friday. In fact, that's why these slides are a bit, because I rewrote them just a couple of days ago. And this is the reasoning in the order. This is the whole order. The posture's changed. The legal arguments are generally have not. They have, actually. They're not the same. And so the same result is appropriate. That's the ruling of the Supreme Court. There's a fantastic dissent by Justice Jackson. And it's a 6-3 decision, which has been true of a whole bunch of these. So I said at the start that I wanted to discuss sort of three things, right? The use of deportation policy to engineer the racial composition of the United States, the present-day treatment of these two communities, which is two very large refugee communities, right? And the role of the Supreme Court in advancing that project. So on the first, I just want to make sure that people have a good sense of the scale of what it is that we're talking about. You have more than 1 million people. What that means is that those people are all subject to summary deportation and detention. Many thousands of them have already been deported. But it also means those are people who will never become permanent residents. Their children will not grow up in this country. Right? They won't be able to sponsor their relatives. Someday they won't be able to vote. Ask yourself, like, why is it true that, say, for example, there's so many Cubans rather than Haitians who dominate politics in South Florida? Just to give one example, you give a million examples like this, right? This is immigration law engineering the composition of the country. And, you know, when we talk about what is the Supreme Court doing in this, I think it's really hard to accept, you know, especially for me as a member of the Supreme Court bar, right, that what we see now is that the court is not doing law. Right? Law rests on reasons. You know, if it's something small, like, oh, an extension of time to your brief, maybe there's just like barely any reason at all. But if you're de-documenting and subjecting to deportation hundreds of thousands of people, the system requires, our system requires that it be based on reasons. And that is not what's happening now. And so it's really, really difficult to think about what the implications of that are. You know, in this moment, I myself can't say that I've sort of figured it all out, but it is something which has changed, it's different, and we have to wrestle with the fact that the Supreme Court is allowing immigration law to do you know, its work in engineering racial composition and not really doing law. Because in this case, the legal arguments would not permit it, because it wouldn't be lawful to allow them to do what it is that they're doing. I just want to close with two final things really quick. At UCLA, actually one of the few things I've done in this last year, which was not litigation, is that I've been part of this group, including a historian and a cartographer and data scientist and other attorneys working with me from my center. And we have managed to get data on and scrape every record of every federal deportation since 1895, when the federal government first started keeping records on deportation. And what they show is that 96% of all deportations actually have been to non-white, non-European countries, most to Mexico and to Central America, but also vastly disproportionate numbers elsewhere. So for example, as many to the Caribbean and to Asia as to Europe, even though obviously there's been so many more people admitted from Europe than from these other places. The site is called mappingdeportations.com. It's really interesting. I encourage you. There's tons of data visualizations and stuff in it. For me, part of why I've been kind of going through it and doing it at the same time is because it's really important to understand the history and how, you know, immigration law, the rules change. But so much of how the system works is actually remarkably consistent over time. And I think it's important to kind of see that. And the other thing I wanted to say was, like, for me, it's really important to remember that there have always been people resisting these things. There were people doing civil disobedience against Chinese exclusion in the 1880s. There were people marching against criminalizing migration. When I first started my career in the early 2000s, that picture from like one of my first times that I was working for the ACLU in Los Angeles more than 20 years ago. And today, there's people doing rock concerts outside of TPS, you know, courtroom hearings and doing tons and tons of organizing, right? So it's always people that have been resisting this. And that's why I say it's not hegemonic. It's not one, oh, it's always, the law is always, no, the law is not always one way. Sometimes it works in favor of discrimination, and sometimes it works against it. And so I see myself as the descendant of people who were benefited from one of those moments of liberalization, as somebody trying to stand on their shoulders and contribute to that movement myself. Exactly how you do it in this moment, I don't know. But I know that there are lots and lots of people doing it lots of different ways. And I'm like happy to say that I'm trying to be part of that movement of resistance. Thank you so much. I really appreciate it.
Thank you so much, Professor. We actually welcome you all to enjoy the reception and speak with our guest and enjoy. Thanks for coming, everyone.